welcome everybody. I'm really excited about this topic that we're going to be talking about today because I feel as though it does not get enough coverage until somebody makes a mistake and finds themselves in hot water. And all of a sudden, after the fact, they are worrying about all of these legal concerns. So why don't we avoid that to begin with and incorporate that in as you're creating your online course, thinking about all these critical legal issues that come up so that you don't have to go back and fix them all over again, or so that you don't have to have any kind of a legal dispute or a problem that can disrupt the flow of your business and just add unnecessary stress. So I'm going to allow our guest for this presentation to introduce herself and to talk more about what we're going to be covering today.
Awesome. Thanks so much, Laura. I'm so happy to be here. My name is Dana Busey Miller, and I am an attorney for artists and creative entrepreneurs based out of Baltimore, Maryland. And I have put together today a presentation about protecting your content online. And let me just pull up the slides. Can you see them?
Yes, I have got them.
Perfect. Awesome. So we're going to talk today about protecting your online content, which it has become really difficult to do in the age of oversharing. And so everybody's putting out lots and lots of great information, but how do you protect what you're putting out there? So first things first, know your rights. What rights do you have in the content that you're creating? You have copyrights. Plain and simple, that's where it all comes back to. So here in the US, it's governed by the United States Copyright Act, and this protects original works of authorship. And this is going to include your online content. So that blog post you write, that e-course you're doing, that press release, everything like that is going to fall under the copyright law. So copyright is a general umbrella that really protects 5 key rights: reproduction, adaptation, distribution, performance, and display. And these are kind of self-explanatory, but just to go through them, reproduction is the actual ability to reproduce the work. So you have that PDF and you're making copies of it or emailing it to people or printing them out at home, or you have a book that you're making copies of your book. That's all going to fall under reproduction rights. Adaptation is the ability to take a work and turn it into something else. So taking a premise from a certain ebook or a certain blog post and then building on it. Distribution is the way in which your material is distributed. So let's say you wrote a book, you would have the rights to then distribute it as an ebook or to sign movie rights away, things like that. Performance doesn't really apply so much in the online world, but this relates to things like plays and movie scripts, things like that. And the right to display is really more for artwork. And this is, displaying it in a gallery or displaying it in a home, things like that. So what it comes down to is what can be copyrighted. And it's also good to know what can't. Copyright does not protect an idea, but what it does protect is your unique expression of those ideas. So while the concept that you have may not be protected, the tangible expression of those ideas is. So when you put pen to paper or when you start typing into WordPress or that blank Word document and you're putting your thoughts down in your unique voice, that's when copyright protection arises. So for example, for all my Harry Potter lovers, the idea to write a book about a young child who discovers he's a wizard and follow his journey, that idea isn't subject to copyright. But as soon as J.K. Rowling started writing that story and expressed those ideas in her words, she's tangibly expressing her ideas in a way that's protected. So it's that act of taking those ideas from your head and putting them down on paper, that's what's going to give rise to copyright. And particularly for online course creators, this is good to know because the same way it doesn't protect ideas, it doesn't protect plain and simple facts. So just because someone else has written an e-course about your topic doesn't mean that you can't write one too. You're going to bring your own voice. You're going to put it in your own words. And thereby you're creating a new, unique work. And that is going to be subject to copyright protection. So how do you get these rights? Do you have to register for them? Do you have them? Where do they come from? You automatically have copyrights to your work as soon as you put your ideas into a tangible form. tangible form means writing it out on paper, typing it into the computer, something that you can essentially hold, and your hard drive counts as something you can hold. You do not have to register to own the copyrights to your work. So I just want to stop there and remind you, you do not have to register to have a copyright. Someone cannot copy your work after you write it. The end. You may need to register to enforce them in federal court, but we'll get to that a little later. So once you have created your work, one of the big things, and this is where I think some people get excited and move on to distributing it and forget, is that you have to proactively protect your content. So you don't just put it out there without taking precautions to be sure that people know that this is your work and that this is your copyrighted material. So some ways that you can start protecting your content right away, and I'd just like to point out, all of these are free, super easy to implement, can be done in under 5 minutes or less. Put copyright notices on your website and your course materials. Password protect your courses and your content. So if you're hosting it on your WordPress, make sure they're signing up as members, or make sure the download has a password for them to access it. That's going to protect you from content scrapers who are scrubbing the web for anything they can get their hands on, then putting it up on their website like it's their own, or distributing your paid ebook for free. You want to be sure that you prevent that. And one of the best ways to do it is going to be to password protect it. You can also watermark your images and your materials. A lot of people really have gotten into watermarking things when they're putting them on Instagram, so that if someone's resharing it, even though they're not supposed to, they still know where it's coming from. Same goes for Pinterest. People tend to watermark their images now, so that even if that pin gets pinned without an attribution to you or your website, people can still see from your URL on the image where it came from. And a big one here is also include a section in the terms and conditions of your course or website that the user agrees to that says they won't share the information they obtain with others. So put them on notice that, hey, thank you so much for buying my course. I'm so excited to go on this journey with you. But just remember, this course is just for your use. And then remind them, if you have a friend that's interested, send them my way. We'll get them signed up and they can start the course too. So for a copyright notice, when you're putting it on your materials, there are 3 things that you need to have. The first is the word copyright, or the C with the circle around it for the symbol, your name or the name of your business, and the year of first publication. If it's something that you update periodically, like a blog, you would do a span of the year of first publication to the present year. So 2014 through 2016, for instance. These can be simple, these can be elaborate, but either way you should have one. So an example there is how I copyright my materials: copyright Dana Miller, 2016, all rights reserved. It's really that simple. Put that in the footer of your ebooks. Put it in the footer of your free printables. Put it on your course materials. It is a reminder to that individual that this material is copyrighted. And sometimes people really just need that reminder. So the next thing, you've done your end. You're doing the basics that you need to do to protect your content, but how do you take it a step further? You need to monitor for copycats. There are so many web scrapers out there. A lot of them aren't even from the US, and they're stealing content. I know I had a blog content stolen one time of a sponsored post I did for compression socks, of all things. And they took the post, they took my images, they even took my disclaimer that said it was my own personal opinions. Why is beyond me, but people will scrape your content. They may also distribute it for free. So if it's a paid PDF, there are websites where that content can be accessed without paying. Or they may be doing one of the worst things, which is plagiarizing it and claiming it as their own. So what can you do to stop that? One of the best things you can do is check out duplicate content detection software. And what this is it's a program that will search the web against your copy and see if it's being produced on another website. So two of the ones that you can check out that I've used in the past are Copyscape and Copygator, and they both have free plans, and you can use those to be sure that your content isn't being reproduced. Another quick tool you can do to find copycats is if you're using original images in your courses, you can do reverse image searches to be sure that they're not being used without your permission. And this can be really important because you may spend a lot of time or energy taking those photos, or you may be paying a designer a lot of money to create those graphics, and you don't want them to end up going viral on Pinterest without a link back to your name. So a simple way to do this is using Google reverse image search. And if you're using Chrome, you just right click on an image and click on search Google for image, and then it'll show you all the results of other places that the image is being used on the web. And then once you have a list of where it's being used, and the same goes for the duplicate content searches, once you know where it's being used, then you can take action to get it taken down. So what do you do now if someone steals your work? You find out that someone out there has copied your information, and after you get over being really angry, you start thinking clearly about what can I do now? Although it's a bummer, if you're putting out good content, people are likely going to steal your work. And it is a reality that we're in right now, but you do have a few options for how to handle it. And the law has caught up with the internet in this particular area, thankfully. The first way is to ask nicely for the poster to take it down. So there are a lot of people out there that just don't know the rules and laws when it comes to sharing. They get excited about something that they found and they want to let everybody know about it. So they share it on their Facebook wall. They copy your recipe in its entirety, or they repost your whole blog post, and they don't realize that there's anything wrong with that. Well, in most of those cases, a quick, polite, informal note asking them to take it down does the trick. So, hey, Jane, I'm so happy you love my recipe for Grandma's apple pie and wanted to share it with your readers. All of my content is copyrighted, so I'm writing to ask that you please take down the full recipe, but feel free to use one of my images with a link back to my post. So in this little quick informal note, you've done two things. One, you've let them know that all the content on your website is copyrighted, and you've asked them to take down the copyrighted material. But at the same time, you did give them permission to use one of your copyrighted images and link back to your post. So you're directing that traffic back to your website. I have written so many emails like this over the years, and in most cases, when you're dealing with a reasonable person on the other end, this is all it takes to resolve. So it doesn't have to be a big ordeal. But sometimes it is. And sometimes asking nicely doesn't do the trick, or the individual is a repeat offender who is constantly taking your content. In this case, you may need to step it up and send them a cease and desist letter. So cease and desist letters, they can be written by you or they can be written by your attorney. Most people find that a letter coming from an attorney's office is a little scarier or maybe more likely to work, but you can certainly write one yourself. But basically, they're notifying the individual that that person is violating your copyrights by reproducing your material, and instructs them to immediately cease their actions and remedy the situation. So this is saying, hey, take that content down now, and please don't continue to do it. But it's not really a request, it's a demand. So a bonus for everyone who is watching this as part of the summit, I'm going to be providing a cease and desist letter, a template that'll be available to you in case you need to do this. So what happens though if they don't respond to your informal request and they just trash your cease and desist letter? You still have options. The next thing is a DMCA takedown notice. So this stands for the Digital Millennium Copyright Act takedown notice. And under the act, there is a notice and takedown mechanism where you, as the copyright holder, can send a notice and demand to the web host or search engine to remove the infringing content. So basically what happens here is that you write a letter to the web host or Google or whoever is in charge of the website that has the infringing copyright on it, and you request that they take it down. Usually there is a page on the host website that tells you where to send your notice and the process for handling it. But once you send this letter to them and you identify your copyrighted material on their website, they then have to take it down under the Act. Where you may run into a little bit of trouble here is when these web hosts are located outside of the US. And in those cases, sometimes it's better to pick your battles. You can still send them a DMCA takedown notice and see if they will voluntarily comply. But just a reminder that the DMCA takedown notice is something that we use here in the US. And also, I will be providing a template for this as well. And just a quick reminder here, because I didn't say it at the beginning, but just because I am an attorney, I'm not your attorney yet. So all of the information that's being presented here is legal information. If you have questions about your specific situation, I strongly recommend you consulting a local attorney, or you can consult me if you want to reach out to me. Copyright is a federal law, so an attorney anywhere in the US can help you. Doesn't have to be someone in your state. So we've talked a lot about how you get your copyrights and what to do to protect them for free and things you can do right now. But you may want to take it a step further and register your copyrights. Now, typically, I tell people that it doesn't make sense to register every single blog post you write because you're going to have a lot of them. But it may make sense to register an ebook that you think could become a bestseller, or your signature course that you want to be sure no one copies because this is a high ticket item for you and it's selling really well. These are times where it's going to make sense to register. And registering isn't that difficult. So 2 reasons why you should register. 1, it establishes a timestamp for when your work was created. So when you file for a copyright registration, that is a presumption that the work was yours and existed at that time. So if someone comes along 2 years later and has content that is identical to yours, you can at least prove that 2 years before you had that. Could have been longer before that you had it, and you may have records to show that as well. But the timestamp that establishes when you file is one that's a rebuttable presumption that you have it. Second, registration is a prerequisite for filing a copyright infringement suit in federal court in the US. So anytime you want to enforce your copyrights, you would have to do it through the federal courts here in the US. And if you haven't filed a copyright registration, you're not going to have standing to be able to sue in federal court. So what's the bottom line? While a registration is not required, again, is not required for you to have copyright in your work, it is a prerequisite for filing an infringement suit. So if this is your signature product and you're going to be very aggressive about protecting it, and this is like your golden product, your moneymaker, and you think that you may actually sue to protect it, you would want to file as soon as possible. Because if you file prior to someone copywriting your work, prior to someone infringing on your copyrighted work, you can increase the damages that you can be awarded. Read here, more money, if successful in the infringement suit. So the statutory damages that you can receive, so basically the money penalty that's assessed against the infringer, can be up to $150,000 per work infringement if you file before the infringement happens. Now, if you didn't file before the infringement, you're not out of luck. You can file for a copyright registration at any time, even after an infringing act. The only difference is that you may not be able to recover attorney's fees and statutory damages. But you will be able to get something like an injunction where they immediately have to stop, and you can get actual damages. So if they did harm to your business or they made money off your work, you're going to be able to recover for that. This area can be a little scary, and copyright lawsuits are pretty expensive, I'm not going to lie. So most of the time, people are going to rely on those demand letters. and cease and desist letters to resolve their copyright issues. But having a registration is going to give a lot more weight to those letters. So it's definitely something to think about. What makes it even better is registering a copyright is really simple. It can be done online now, and it takes probably start to finish about 15 minutes to get through the whole application. So the first thing you'll do is submit an application along with the appropriate filing fee to the U.S. Copyright Office. If you're filing online, it's $35 for a single work, and I believe it's $55 if you're doing a compilation of works. So the difference between those is a single work would be like one ebook. But a compilation of works could be if you're a photographer and you have a collection of 50 photos that you want to register together. When you have a lot of information that you're going to register together, a compilation can really be the better way to go. That way you're not paying $35 for every single photo. Along with that application, you're going to include one copy of the work if it's an unpublished manuscript, or 2 copies of the work if the work is published. And then you wait. And this can be the frustrating part. Right now, it can currently take up to 8 months for electronic filings and 14 months for paper filings. So it's even more of a reason to file online, aside from it just being simpler. But it does take a while. Now, your application gets processed 8 months later, but that filing date is what you're going to be looking at for establishing your copyright date. When you're making your online courses, you really want to also be careful not to infringe on the rights of others. We've talked a lot about your rights, but don't forget about other people's rights when it comes to online courses and online content. Be sure if you're quoting someone or you're quoting a particular study or statistic or your figures, cite your sources. Give a shout out to who gave you the information. You definitely don't want to plagiarize or don't want to be copying someone else's content. Second, don't use images without permission. This is one of the biggest copyright faux pas I see on the internet. People are snagging images from Google and they're throwing them into their PowerPoints or their slide decks or their ebooks, and that's copyright infringement. If you want to use images, there are some amazing, great sources out there. Like Unsplash, Pexels. Those are places where you can get royalty-free images that you can use for both your personal and commercial products. And you can also look at Creative Commons images, so things that allow you to reuse them. Creative Commons 0 is going to give you the most rights, and there are a number of other licenses. So you just want to be sure that you're reading the terms and that you understand what you're permitted to do. And when in doubt, ask for permission first. If you want to share someone's content, or you want to quote them, or you want to share an image with a link back to their site, ask them. A lot of times online, people are happy that you're sharing their work, but they're also going to be happy you asked first. You can also look on their website to see if they have a sharing policy or an expanded copyright policy. So some of my favorite blogs, for instance, have permissions on their website that say you can share one image from our post along with a link back to our site. And so as long as you're complying with those terms, you're in the clear. If you're having a website, you may also want to think about doing that. But that really depends on what type of content you're putting out and if it makes sense to do it. When you're doing a course, you're not going to want people sharing your course material. So I would caution you against that. But what you may want to have is a freebie that you could point people to, and they could get a taste of your course, but they're still directing them back to your website. Again, though, just when in doubt, ask for permission. So how can you reach me if you have more questions? You can reach me through my new website, which is forcreativeentrepreneurs.com or forcreativeentrepreneurs@gmail.com. And there are tons of resources for how the law works with your creative business. And there's information there about copyright, about creating content and some of the different aspects of running your business, like having contracts in place. There are templates for that, and forms and templates for privacy policies, terms of service for your website. Basically everything you need to get your online business up and running. So I'm sure Laura's going to join us back now, and she probably has a ton of questions for me that I will be happy to answer.
I do have a couple, and sort of the first thing I wanted to talk about is honestly just like you did cover it in your presentation, and it's something I see a lot of people making this mistake too, like assuming, oh, I'm creating a free ebook, or this is on my blog and it's free, so it's cool for me to just hop over to Google Images and search, person playing with puppy, and then take whatever picture pops up. And that's something that you cautioned against, and I just wanted to speak from personal experience too, having seen people who've been really burned by that. And 3 of my law firm clients have had that experience where a previous writer either didn't know any better or was doing things as quickly as possible, used pictures that were actually they were owned by Getty Images on their blog post. Nasty letters from Getty Images. One was a $5,000 lawsuit. I mean, there are consequences for doing things like that. You might think it's innocuous, and in this sort of thing, it doesn't really matter what your intent was. What matters is that you used material that wasn't yours. So anytime that you're creating anything, ebooks, courses, PowerPoint templates, forms you're giving away, when you're using someone else's material without permission, and they find out about it, you're always putting yourself in that situation. And one of the ways that I've avoided this problem is, of course, you can use the royalty-free stuff, but then I realized, because I use so many images for my clients and for my own presentations, we just purchased a monthly membership to have all the images be properly licensed. And I love that because, with something like Adobe stock photo or deposit photos, I pay $30 a month to get 30 pictures from deposit photos. But then if anyone asks questions, I've got a history of everything we've ever downloaded and can say, oh yeah, I downloaded that on January 6th. I followed all the terms that are, allowed for that particular photo. So even with that, you want to be careful, because some of those pictures are editorial use only, or they have a limit on, like, if you're putting it on the cover of your book, there are certain things where it says if this is going to be more than X copies made, it's not, licensed for commercial purpose. So the bottom line is that the fine print matters on that stuff.
It does. And there are definitely options out there for every budget. So if you're someone who is just starting out, there are places like Unsplash, again, for instance, where those pictures are coming direct from the photographers who took them, and they're licensed for whatever you want to do with them without attribution. But you have to be careful when you get into Creative Commonses, because some of them do have those restrictions. So no derivatives, non-commercial, must have attribution. I always suggest that if you are using any pictures off the internet, you take a screenshot or save the license with the picture, especially if you're going to be selling something. You want to be able to show, if anyone comes back and say, hey, that's my photo. No, here, this is where I downloaded it from. Here's my license. I complied with everything I needed to do, and keep that in your records, because it is really scary when you get one of those letters for Getty Images. And I think the largest demand I've seen was $16,000 at the last firm I worked. And it was crazy because the woman had no views on her blog. We had the statistics. She literally had no views. They found it using Google reverse image search and sent her a letter for $16,000 demand. So please know, those are not internet urban legends. It does happen. If you use a Getty photo, it will probably happen to you. And please save yourself that headache. And especially too with like Canva. Canva's images are $1. They're $1. $1, and you save yourself that headache. I promise you it's worth it.
Yeah, spending that $1 or spending literally the extra 1 second to screenshot where you're pulling this from, with the terms right there, it might seem like, oh, that's too tedious. I don't want to get into that. But given that it actually could save you hundreds or even thousands of dollars, because you want to have evidence on your end too, because if someone's getting to the point where they're sending you a letter or they've hired a law firm on their behalf, they probably have some form of evidence on their side. And even if you did have good intentions and you did do the right thing, you want to have something to back you up as well. And I am just amazed because I've seen this for years, and it's like, it doesn't seem to be getting better. It seems to be getting worse. I mean, I used to work for a website that they were posting like 3 blogs a day and just pulling the images right off Google. And finally I said, I cannot write for you anymore because I do not want my name attached as the blog writer where you're using stolen images. And I've told you like 100 times, don't do it.
For anyone who is thinking, I see people using images all the time on their website and they put via or they put a link back. That is not enough to save you from copyright infringement. Crediting your source is not enough to reproduce that image. And I can't emphasize that enough. And just because everyone else is doing it does not make it right, and it doesn't make it okay. So please do the right thing, respect other people's copyrights. You want them to respect yours. And to piggyback on what Laura just said, if you come to me as an attorney when you get one of those letters, the first thing I'm going to ask you is, where did that image come from? Where did you find it? How did you license it? How did you get to the point where you used it on your website? And if you don't have anything, I don't have anything to go off of to defend you.
Exactly. And given that there are so many great websites out there where the photos are either free and properly licensed or relatively cheap, like $1, there's just no excuse. You can find another picture of someone doing yoga on a mountain. There's 2,000 of them in any stock photo database. So you do not need this particular one, and especially with the advent of Canva, it's so easy to create your own stuff using things that are properly licensed. It's just not worth the risk. And yet people continue to do it. So if you could sort of, you've kind of been on both sides of the table here and have great experience in this, what would you say are like the 2 biggest copyright mistakes that you see people making over and over again, whether it's with their own work or someone else's work?
I think one of the biggest ones is copying from others without attribution. And it can be a photo that you don't have permission to license in your work that you're incorporating. It can be taking someone's work to build on it and not changing around the content enough, not making it your own. So remember that copyright protects your unique expression of an idea. So you need to be putting things in your own words. You can't just take someone's content, rearrange a few sentences or rearrange a few paragraphs. You really need to make it your own. So I think that sort of plagiarism is where people get hung up. And I don't think it's necessarily always intentional, but when you get stuck with that, and this is my biggest tip to everyone, when you're trying to write, especially if you're trying to write a course, start writing it out the way you would explain it to your best friend. Because when you do that, it's going to be in your voice and those are going to be your words. So even if you've read everything there is to know on the internet about it and you've gleaned all that information, put it in your own voice. That you have to set yourself apart. So that would be the first one. The second one, I think, is not being proactive about taking the steps to put people on notice that their work is copyrighted and then getting the takedowns. I see a lot of people complaining that people steal their work, but they don't put in the work to protect it. And I know that that's really frustrating and kind of counterintuitive that the burden is on me to stop people from stealing my stuff. But it's part of the era that we're in. We are, for better or for worse, in the era of oversharing. Everybody is sharing anything and everything on the internet. And some people just genuinely don't realize what they're doing is wrong. Some people are content scrapers and they're going to do it whether you send them a letter or not. But it's on you to be sure that your content is being protected. That's ultimately your role. Now, it's not like trademarks, because with trademarks, if you don't protect it, you can lose it. With copyright, you still keep your copyrights. So it's not a use it or lose it kind of right, but you dilute the value of your work if you're not protecting it. And I think that is where people run into trouble, especially if you let it get out and it gets on one of those free download sites. It's like, well, even if I know it's copyright infringement, why would I pay you $97 for it when I could just download it over here in 2 clicks? And you don't want to do that with your business. You don't want to set your model up that way. You don't want people to be getting illegal copies. You want to be creating a fan base that loves what you do and wants to come back to you and support you.
Yeah, absolutely. That's such a good point about all of the time and the energy that you put into creating an online course, but you're missing this important component of avoiding risks or mitigating them at least by not protecting it. So, we all know how many hours it takes to create an online course, all of the creation and the back and forth time and, questioning yourself and testing things. It's a tremendous amount of work. And for things that really aren't going to take you that much time, or even if you invest, in paying an attorney to help you with some of this, the potential rewards are so much greater. So another thing I see people doing, and I'd love to hear you sound off on this since you're an attorney, and I know you're not my attorney, you're not anyone's attorney who's watching this, who was going to include that disclaimer in there. But I see people doing this a lot too. When it comes to their terms and conditions and privacy policy, they just copy and paste from someone else. So what do you think about that? And is that something that you really should be going to an attorney for, or is that okay to borrow someone who's already kind of done that?
So I have mixed feelings about this, and I think it really comes back to your website. First things first, if they wrote it and it's original, it's technically copyrighted. So you can even be copyright infringing terms of use and terms of service. So there's that. But there are some generators out there that you can use that you can plug in some different facts about your website and will spit out something basic. I think having something basic is better than nothing at all, but having something tailored to your website is going to be the best thing to do. It is something I think you can do yourself if you educate yourself on what needs to be in them. But I also always think it's a good idea to talk with an attorney about what you need, or at least do some digging on some legal information websites where you can find that. I know over on our website, by the time this goes live, I will have templates for those with instructions on how to customize it. So you could definitely take a look at that. But for instance, like a privacy policy, the core things that need to be in there are: what information are you collecting from your visitors? How are you using it? And how are you protecting it? So you need to make it clear, like, we're collecting email addresses and IP addresses and cookie tracking or something like that. And then how are you using it? Okay, well, we're using it in aggregated form that doesn't identify the individual user to improve website efficiency, or we're only using it to send you information that you've opted into. And then how are you protecting it? Well, we're not selling your information to anyone else. So it's safe with us. We're not going to spam you. We're not going to sell it. So having like those types of things in your privacy policy, that's what's going to cover you. So I think most people, if you're savvy enough to be writing a course and having an online business, you probably can find a way to word that yourself. Or you can tweak a template from one of those generators that are floating around and get it to your website. But I would never lift something directly from someone else's site, just because they probably tailored it to their site and it may not make sense for yours.
Mm-hmm. Yeah, you always want to have things that are at least partially customized, particularly if the other site is doing something that you're not. If there's information on there, like I sometimes will see terms and conditions that just simply do not apply to the website they're being copied onto. And you want to be careful about that, because if you're saying that that's your policy and someone comes back and says, well, hey, it was on your website that, you offer refunds or whatever it might have been, you got to be careful about that when you're copying and pasting. So there's one more thing I want to ask you about, which is a little bit off the beaten path, but it's something I've often wondered about. When you're creating a course, people who at least have a little bit bigger business or a large business are making use of subcontractors to help them in the creation, the marketing, the distribution of this course. Do we need additional protections? Do they need to sign a non-compete agreement? Do they need to, do we need to outline in some way that they're not licensed to take this material or steal it or pursue clients we've collected? Is there a concern there, or is that really, not much of an issue?
I mean, I hate to say like it's not much of an issue and then it happens. I mean, it does happen. But I think anytime you're working with individuals, first of all, you should have a contract in place with them. So anyone you're bringing on as an independent contractor to work with you, you should have some kind of agreement. And I typically recommend having encapsulated within that agreement a confidentiality clause that basically says that any information about you, your products, and your business that they're receiving by nature of working with you is going to be kept completely confidential. Non-competes, I don't think fit quite as much as confidentiality here. So a non-compete would be something like, oh, you can't go create another course about this topic based on the information you learned with me. That may be something that concerns you, and you could certainly put a clause in there. But if you're hiring a graphic designer, chances are that graphic designer is not going to go make a course about writing. They're going to make their own course about something else. But confidentiality is a big one because it would be really easy for your graphic designer to have a friend who wants to be a freelance writer and say, oh, I just did this design work for this client, Laura, and she has this amazing course. I have all the materials here. Let me show it to you. You might get a lot out of it. So confidentiality would protect you against something like that. They don't have to be separate agreements. They can be clauses within the agreement that you have with them. But I definitely think it's important to have that in there.
Okay, that's great. That's really good to know. Well, I know I have learned a lot by watching this, and I'm excited to grab your templates too, because I know I need some of them, and I know other people who need them too. So are there any sort of like last thoughts or like a recap of maybe one key thing that you really want people to walk away from this presentation knowing?
I think it's basically just know that even if you don't do anything else, you have rights. So don't feel defeated. If someone is copying your content, one, they're copying it because it's something worth copying. So you should feel awesome about that. So you're putting out good work. But know that you do have options and you do have rights. So you don't need to feel helpless that someone has reproduced it. It's just about keeping a level head and then working through the process of getting that taken down. And it may take a little legwork. It may take a little bit of perseverance, a little bit of digging, through the who is to find out who owns the website or through their web host to figure out who you need to send it to. But there are options. So just know that the second you start creating your material, you have rights in it, that those rights are valid, that they're important, and they deserve to be protected just the same way your work does.
A really, really great point. And we'll put all of your contact information and website and all that good stuff below the video. But just one more time for everybody, where can we go to find out more information about you and the services you offer?
forcreativeentrepreneurs.com.
All right. Awesome. Thanks so much, everybody, for tuning in, and we'll see you tomorrow.